Imagine waking up tomorrow and you just discover the government has quietly rewritten the rules of the entire justice system overnight. I mean, no votes from Congress, no televised floor debates, no public hearings.
Right, just a memo.
Yeah, literally just a bureaucratic memo that goes live on a Monday morning, and it fundamentally alters who gets a fair trial and who doesn't.
It sounds like a dystopian novel, honestly, but in the realm of administrative law, it is a very real, very potent mechanism.
And that is exactly where we find ourselves today. So picture this. It's late Sunday night, March 8th, 2026. The weekend is winding down, but in the corridors of Washington, D.C., the tension is just absolute.
Because Monday morning is the deadline.
Exactly. Just hours away is the launch date for this sweeping, historic overhaul of the United States immigration appeal system. The executive branch is, primed to flip the switch on a completely new machine designed to drastically accelerate deportations.
Right, they are ready to go.
But then, just before the clock runs out, a federal judge in D.C. named Randolph D. Moss drops a 73-page ruling.
Yeah.
And with just the stroke of a pen, he brings the entire overhaul to a screeching, grinding halt.
Yeah, a 73-page judicial roadblock dropped directly in the path of a major presidential policy initiative. I mean, it is a profound intervention.
Which makes this the perfect mission for today's deep dive. We're going to unpack the incredible tension between the government's push for basically uncompromising efficiency and the absolute legal bedrock of due process.
Yeah, we're looking at the specific, granular mechanics of this blocked fast-track rule, the deep legal reasoning involving the Administrative Procedure Act, and really the broader collision happening right now.
Right, the collision between executive enforcement goals and judicial oversight.
It's a fascinating case study because it takes these highly abstract concepts, statutory authority, procedural frameworks, and it shows exactly how they dictate real, life-altering consequences for people.
Okay, let's unpack this. To understand why a federal judge felt compelled to step in at the 11th hour, we first need to look at the battlefield. We are talking about the Executive Office for Immigration Review, the EOIR, and specifically its appellate arm.
The Board of Immigration Appeals, right, the BIA.
Right. Now, for anyone who follows immigration policy, the BIA is the administrative appellate body reviewing deportation rulings. But what is crucial here is the sheer scale of the environment they're operating in.
Exactly, because the BIA isn't operating in a vacuum. It's operating inside a system that is just buckling under a historic, crushing backlog. I mean, we are talking about hundreds of thousands of pending cases.
Hundreds of thousands.
Yeah. Over the years, a combination of surging asylum claims, a severe bottleneck of available immigration judges, and, chronic underfunding has created this massive administrative logjam.
And that logjam is really the driving force behind the Trump-Vance administration's strategy here. If you make campaign promises centered on large-scale deportations and the strict deterrence of irregular migration, well, a multi-year backlog is your worst enemy.
Absolutely. You simply cannot execute an enforcement surge if the appellate safety net takes months or years to process a single case.
Right.
So administration officials looked at the existing appellate system, which included 30-day filing windows and comprehensive briefing periods, and they basically saw nothing but weaponized inefficiency.
They viewed these procedural steps as loopholes.
Yeah, loopholes being exploited to delay final removal orders. So on February 6, 2026, the EOIR issued an interim final rule. It was titled Appellate Procedures for the Board of Immigration Appeals, and their goal was to clear the bottleneck by fast-tracking the entire system.
But calling it a fast track almost feels like a euphemism, right? When you look at the actual mechanics of what they tried to implement, the government's new rule was built on 3 major procedural changes, and they function less like a streamlined process and more like a series of tripwires.
Yeah, tripwires is a good word for it.
Let's look at the first one, which is the timeline. Under the traditional system, if an immigration judge rules against you, you have 30 days to file a notice of appeal. The administration's rule slashed that from 30 days down to just 10.
Just 10 days. And we really need to pause and think about the physical reality of what a 10-day window means in this specific legal context.
It's basically nothing.
It's nothing, because this isn't corporate litigation where a team of associates is sitting in a Manhattan high-rise ready to draft a brief. We're frequently talking about individuals who are held in remote detention facilities.
Right. Facilities that are often hours away from any major urban center where appellate lawyers actually practice.
Exactly. So within 10 days, an appellant has to secure a lawyer, assuming they can even get consistent access to a phone, which is a big if.
Huge if.
They have to overcome significant language barriers, often requiring translators just to understand the judge's initial ruling. Then they have to draft a legally sound notice of appeal, and then they have to physically mail it so that it is received and processed by the BIA within that exact 10-day window.
I mean, it takes the Postal Service 4 days just to deliver a certified letter across the country sometimes. The government slashing the deadline to 10 days to fix their own backlog is, it's a bit like a restaurant burning your dinner and then telling you that you only have 30 seconds to eat it so they can quickly clear the table.
That's a great analogy.
It shifts the entire burden of a broken system onto the individual.
It really does. And the compressed timeline is only the beginning. The second major change fundamentally flips the presumption of the appellate system on its head through something called automatic summary dismissals.
Right. This is where the underlying logic of the legal system gets completely rewritten. Normally, if you manage to file an appeal, even under a tight deadline, the baseline assumption is that you have a right to a meaningful review. Like, the court is obligated to at least look at the merits of your claim.
But under the government's new rule, cases would be presumed dismissed by default. They are automatically rejected unless a very specific, highly improbable sequence of events occurs.
Wait, they're automatically rejected?
I said automatic.
And what's that improbable sequence?
So a majority of the permanent BIA members have to explicitly vote to accept the case for a full review, and they have to do it within that same 10-day window.
Wow. That's just a stunning procedural hurdle. I mean, meaningful review goes from being a standard structural right to an incredibly narrow exception.
Exactly. It requires proactive majority approval from a board that is already drowning in cases, and they have to do it within a matter of days. If the board is too busy to look at your filing, or if they, tie in their vote, your deportation is finalized by default.
That's incredible.
Yeah.
But even if you miraculously beat the 10-day clock, and even if you somehow win the lottery of getting a majority board vote in under 2 weeks, the government added a third trapdoor. And this is the one that really caught the attention of legal scholars.
The waiver provisions.
Yeah.
The waiver provisions are arguably the most aggressive teeth of this entire overhaul. The rule stated that absolutely any legal issue, any defense, or any argument that you did not explicitly raise in that very first 10-day notice of appeal is treated as permanently waived.
It's just forfeited entirely.
Forfeited. Gone.
Which completely, fundamentally misunderstands or, intentionally ignores how appellate law actually works. When a trial ends, lawyers don't magically possess all the facts. They have to wait for the court reporters to transmit the official record of the trial.
Right, you need the transcripts.
Yeah, they have to read the transcripts, research emerging case law, and write comprehensive briefs over weeks or months to develop their legal claims.
Exactly. Sometimes a vital piece of legal precedent is decided by a higher court, say 2 weeks after your initial filing. Under normal circumstances, you would incorporate that new precedent into your final brief.
Yes.
But under this new rule, if an argument wasn't crammed into that initial rush filing, you are legally forbidden from ever bringing it up. The judge is literally barred from considering it.
So you are forcing appellants to front-load every conceivable legal argument before they even have access to the trial transcripts, with zero margin for error.
Zero margin for error. You are creating a system where the procedural obstacles are so high and the window for compliance is so narrow that the vast majority of appeals will fail on technicalities before a judge ever reads a single word about the actual human being involved.
Which brings us to the core conflict. If the executive branch has the authority to run the immigration courts, how did a single district judge justify stopping this sweeping overhaul? This is where we move from the what of the rule to the how of its implementation.
Right. The legal mechanics.
And it all hinges on a foundational piece of American law called the Administrative Procedure Act, or the APA.
The APA is essentially the constitution for the bureaucracy. It's the invisible scaffolding of the administrative state. It was created back in 1946 because the federal government was expanding rapidly, creating all these new agencies with immense power to regulate everyday life.
Congress realized they needed a standardized rulebook, right, to ensure these unelected agencies couldn't just dictate laws by fiat.
Precisely. And the core safeguard of the APA is the notice and comment period. When an agency wants to make a new rule that affects the public, they are legally required to publish a draft of that rule and give the public, usually for 30 to 60 days, a chance to weigh in.
So lawyers, advocates, industry experts, and regular citizens submit feedback.
Yeah. And the agency must formally consider and respond to that feedback before finalizing the rule. It is quite literally the only direct democratic lever the public has on the administrative state.
But the Executive Office for Immigration Review didn't do that here. They bypassed the APO entirely. They published this overhaul as an interim final rule.
Meaning it skipped the draft phase.
Skip the draft phase, skip the public comment period, and went straight into immediate effect. And their legal justification for skipping that democratic process was that they had, quote, good cause.
Yes. The APA does have an emergency escape hatch. If providing a public comment period would be impractical, unnecessary, or contrary to the public interest, an agency can claim good cause and bypass it.
And that's what they tried to do.
Right. The Department of Justice argued that the crushing historic backlog of hundreds of thousands of cases constituted an acute crisis. They argued that waiting 60 days for public comments would only allow the backlog to grow worse, further paralyzing the system.
Okay, wait, let me push back on the judge's ruling here for a second. Because the government's argument isn't entirely baseless, is it? I mean, if the system is genuinely drowning in a historic backlog, if we are facing a state of absolute administrative paralysis where justice is delayed by years, couldn't a reasonable person argue that that is a valid good cause?
It's a fair question.
Like, if your house is actively flooding, you don't post a 60-day notice on the door asking for public comments on plumbing solutions. You shut off the main valve immediately. Isn't a systemic collapse a valid reason to get the gears moving right now?
It's a very compelling argument, and it is the exact defense the administration mounted in court. But it is fundamentally flawed when applied to constitutional rights, and that is why Judge Moss vehemently rejected it.
How so?
Using your analogy, the EOIR wasn't just shutting off a leaky valve. They were demolishing the entire foundation of the house without a permit.
Ah, I see. So how did Judge Moss frame it in his 73-page decision?
He essentially said that you cannot use the existence of a chronic, long-standing problem as an excuse to declare a sudden emergency that strips away public oversight. I mean, the backlog has existed for years.
Right, it just happened on a Tuesday.
Exactly. It is not a sudden, unforeseen crisis that justifies panicking and throwing out the rulebook. It's more like a software company pushing a massive mandatory update to your phone's operating system overnight without any beta testing, claiming it's an emergency patch, but the update actually removes your ability to make phone calls.
Because the changes were just too transformative.
Exactly. Judge Moss found that the EOIR violated the APA because this wasn't a minor administrative tweak. This was a sweeping, fundamental rewiring of the appellate framework. When you rewrite the fundamental rights of appellants, rigorous public scrutiny isn't just a formality, it is a legal requirement.
And what's really vital to understand is that Judge Moss didn't just stop at the procedural foul of skipping the comment period. He dug straight into the bedrock of the Constitution. He pointed out a severe, immediate danger regarding the Fifth Amendment.
Yes, the Due Process Clause. What's fascinating here is how Moss zeroed in on the practical reality of the 10-day deadline and the presumption of dismissal. He noted that the government's new machine was explicitly designed to create a system where the overwhelming majority of appeals would receive literally zero substantive consideration.
Zero substantive consideration, meaning the court isn't weighing the facts, they aren't looking at the law, they aren't deciding if the deportation is just. They're literally just checking a timestamp and throwing the file in the shredder.
Correct. And Moss emphasized that when the government systematically strips away substantive consideration from an established appellate process, it is a glaring due process violation.
Wow.
You are effectively denying people their day in court, not by hearing their case and ruling against them based on the law, but by procedurally engineering a maze so complex that they can never make their case in the first place.
It's important to note the sheer firepower that was brought to bear to secure this midnight ruling, too. This lawsuit, which was filed in late February 2026, it wasn't the work of one rogue attorney. It was a massive, highly coordinated legal strike by a coalition of heavyweight organizations.
Oh, absolutely. The biggest names in immigrant rights.
Yeah, you had the Amica Center for Immigrant Rights, Brooklyn Defender Services, the Florence Immigrant and Refugee Rights Project.
HIAS, the American Immigration Council, and the National Immigrant Justice Center.
Right. All of them represented by Democracy Forward.
They saw the March 9th effective date looming like a cliff edge, and they understood exactly how catastrophic this would be for their clients. It was a desperate 11th hour sprint to secure an injunction before the new rules locked into place.
Now, before we go further, I want to make something very clear to you, our listener. This legal ruling did not happen in a vacuum. It is a major flashpoint in a much larger ongoing political and systemic struggle regarding Article 2 executive power versus Article 3 judicial oversight.
It's incredibly polarized.
Yeah, so to really understand the stakes of this deep dive, we're about to look at the highly polarized reactions to this ruling from both the left and the right. And we want to be incredibly clear. We aren't endorsing either of these viewpoints or taking a side. Our goal is simply to hold a mirror up to the source material so you can see how this legal battle is being framed by the different factions involved.
Exactly. And the divergence is stark. If you look at the immigrant rights advocates, they celebrated Judge Moss's ruling as a vital, life-saving defense of fundamental rights. They view the judiciary as the ultimate necessary firewall against executive overreach.
Their framing uses very urgent existential language. Groups like the American Immigration Council describe the fast-track rule as a calculated attempt to eviscerate non-citizens' right to appeal.
They argued that the judge's intervention prevented hurried deportations to dangerous conditions.
Right. From their perspective, without this midnight block, countless individuals with entirely valid legal claims for asylum would have been deported into harm's way simply because they missed a 10-day bureaucratic window.
But if you flip the lens and look at the administration and conservative legal scholars, the narrative is completely inverted. To them, the intervention itself is the crisis.
Right. They see an unelected judge hijacking a presidential election mandate.
Exactly. Supporters of the administration's agenda were quick to point out that Judge Moss is an Obama-appointed jurist, framing his 73-page roadblock as a textbook example of judicial activism.
They view it as obstruction.
Yes. From their perspective, the executive branch was elected with a clear democratic mandate to secure the border and restore efficiency to a broken system. They view the courts as inappropriately tying the government's hands, intentionally perpetuating the exact administrative paralysis the administration is trying to fix.
And you really have to zoom out and look at the broader 2026 enforcement context to see why the administration was pushing this specific rule so aggressively. Since taking office, the Trump-Vance administration has made sweeping moves. They have reported deporting hundreds of thousands of individuals.
They've aggressively altered temporary protected status.
Right, the TPS programs for countries like Haiti and Somalia, stripping protections from long-term residents. And they have systematically appointed new immigration judges who possess strong, hardline enforcement backgrounds.
When you look at that broader picture, you realize this BIA overhaul wasn't just an isolated procedural update. It was the engine designed to clear the runway for all those other enforcement goals.
It's the linchpin?
Exactly. You can hire all the enforcement-minded judges you want, and you can mandate the deportation of hundreds of thousands of people, but if the BIA remains a bottleneck where cases sit for 2 years, your entire agenda stalls.
The gears grind to a halt.
Fast-tracking the appeals is how you convert enforcement policy into actual physical deportations at scale. This rule was the explosive charge meant to clear the logjam.
So what does this all mean? We have a midnight ruling, we have a blocked overhaul, we have a constitutional clash over due process. Where does this leave the system on Monday morning?
Well, the immediate practical impact is that Judge Moss's ruling preserves the status quo. Because he vacated those highly problematic sections of the interim final rule, the traditional safeguards survive, at least for now.
Meaning appellants waking up on Monday still have their 30 days.
Yes. The 30-day filing window remains intact. The automatic consideration by the BIA survives, meaning there is no default presumption of dismissal, and lawyers retain the ability to develop and raise new legal issues as they receive trial transcripts and brief their cases over time.
So the structural integrity of the appeals process holds.
It holds.
But the reality is this ruling only buys time, right? It's a pause button, not a permanent stop. The underlying pressures haven't vanished. The hundreds of thousands of backlogged cases are still sitting there. The executive enforcement surges are still happening.
And the administration has multiple avenues to fight back. They could appeal Judge Moss's decision to a higher federal court, arguing that his interpretation of the APA was overly restrictive.
Or they could just do it the long way.
Right, the path Judge Moss explicitly left open for them. They could spend the next few months pushing this exact same fast-track rule through the proper APA public comment channels. They could publish the draft, take the 60 days of public feedback, formally respond to it, and then finalize the rule anyway.
So the battle over these deadlines is far from over. As we wrap up this deep dive, I want to bring this back to why this specific case matters so much to you, even if you never set foot inside an immigration court. This whole saga, the skipped comment periods, the 10-day trapdoors, the midnight injunctions, it is an absolute masterclass in how the administrative state actually functions in this country.
It really is.
It shows us how the courts serve as this massive foundational check on executive power, ensuring that a government's pursuit of ruthless efficiency doesn't steamroll over procedural fairness.
If we connect this to the bigger picture, it's a stark reminder that while we often talk about the law in very dry academic terms, deadlines, waivers, statutory authority, these are the actual mechanisms that decide human fates.
Yeah, real lives.
In the high-stakes arena of U.S. immigration policy, lives, physical safety, and the unity of families hang entirely in the balance of these seemingly minor technicalities.
It is the ultimate friction point between the cold machinery of the state and the human being caught inside it. And that leaves us with a final lingering thought for you to explore on your own. The Board of Immigration Appeals, the BIA, is an administrative court. That means it is not part of the independent Article III judicial branch,
Right, it sits entirely under the control of the executive branch.
specifically the Department of Justice. The Attorney General can literally rewrite its rules or overrule its decisions. If the very definition of due process and fair review can swing so wildly simply because a new administration takes control of the agency is true, blind justice even possible in a system that is inherently political by design?
It is a profound question. It really cuts right to the heart of how our modern government operates.
Something to definitely think about. Until next time.